Hi, I'm Mike Matray, your host of Healthcare Matters, where the medical and legal communities come together to discuss healthcare matters. Today's guest is Whit Johnson. Whit is a shareholder with Curry, Johnson, Griffin, and Myers in Jackson, Mississippi, where he specializes in trial work, focusing his practice for the past 30 years on the defense of physicians, hospitals, and other healthcare providers from claims of medical negligence. He was recognized as Lawyer of the Year by Best Lawyers for 2011 in the field of medical malpractice law. Mr. Johnson is a frequent speaker to medical organizations, including the Mississippi State Medical Association, the Mississippi Medical and Surgical Association, Medical Assurance Company of Mississippi, and various departments and groups within the University of Mississippi Medical Center. He has been published in the Journal of the Mississippi State Medical Association on both risk management and litigation issues. Welcome to the program, Whit.
Thanks. Glad to be here.
How has the move from paper medical records to electronic medical records affected best practices for entering data into a patient's chart? And what guidance would you give physicians so that they are using best practices when entering data into the patient's medical records?
You know, I'm not sure that the best practices themselves have actually changed. The best practice is simply to pay attention and be focused on documenting in a timely and accurate in an accurate fashion. But having said that, I think the guidance that I'd give to my clients is that you need to be focused and pay attention. There are a couple of things that you can do. You can be sure that you are the only one entering information into the chart. You can be sure that other people who may have access to the chart, that you take the opportunity to review what they have done to be sure that y'all are consistent. You know, you don't want to get, I guess what's best called is clickitis, which is where you literally are just clicking down through various boxes, showing them all as normal because you have to click on one box to get to the next box. So, but having said all that, it's no different than before. Pay attention to what you're doing and put it in right and put it in on time.
A recent RAND Corp American Medical Society study called for a complete design overhaul of electronic medical records to improve usability. If you had the opportunity to advise an EMR company on a redesign of its products, what changes would most benefit the defensibility of a medical liability claim?
You know, the primary thing I think most defense lawyers would tell you is that we need to do away with the templates that are so ubiquitous now. The interesting thing is that doctors have always used templates, even before EMR. You can look at you can take a surgeon's op reports from 5 similar surgeries, and they will be almost identical with just minor changes. So they were using templates in their mind, even if they weren't created. And I don't know that we will ever get fully away from the templates, but I think the thing that bothers me more than that is the drop-down boxes. So often the drop-down boxes don't include what they need to include. There really needs to be one for other, and the doctors need to pay attention and use that other box as often as it is applicable. I would also like to see a situation where you aren't required to click on every box. On the history and the physical exam, a lot of times these doctors have to click on every separate system without regard to whether it has anything to do with that particular patient's issues that they're seeing the doctor for. So I'd like to see a situation where the only thing that a doctor clicks are the pertinent negatives. And then finally, one of the things that I would love to see happen, I would love to see a situation in which the patient is part of the electronic medical record. I know that sounds funny, but I would love to see a situation where when the patient goes into the doctor's office, you sit them at a computer and they fill out things. They type in what their chief complaint was. They type in the medicines they're on. They type in if they have anything else going on. And then that goes into the chart. And if you're not going to set it up electronically, then get them to fill out. Get them to fill out every time they come in, why they're there, what's going on with them, do they have any other problems, what other doctors are they seeing, and then scan that into the EMR. And that way, when I'm defending a case, I've got the patient's own words describing the history.
An EMR's audit log and access log can be an Achilles heel when defending a medical malpractice claim. Can you explain the audit access log to our viewers, how plaintiff's counsel can exploit it, and how a healthcare professional can avoid these specific pitfalls when using an electronic medical record?
Well, first off, let me say I'm not sure you can ever avoid them. And I suspect most of the doctors out there have children, and I suspect that most of those children are on social media. And I can guarantee you, every one of those doctors has sat down and told their child, "Do not post something on the internet that you don't want everybody to see, and you don't, and that you won't, and that you might be ashamed of 20 years later, because once it's on the internet, it's there forever." Well, let me tell you, once it's on a computer, it's there forever too. And it is not only there, it is there as to when it got there, it is there as to what changes have been made, it is there as to who put it there. Every piece of information that has anything to do with that information is on the computer. That's why they call it metadata. Meta essentially meaning everything. It is information about information. And the only way to avoid the pitfalls is, it gets back to the first question you asked about EMR and best practices. You got to put your stuff in on time, and you've got to put it in accurate, because if you don't and you try to change it, the plaintiff's lawyers will know who changed it, they will know when it was changed, and they will know what it was before you changed it. There was actually a study up out of, I think it was out of Kansas. It's in the 2008 Journal of American College of Surgeons, and that was where they studied all of the different times that various specialties got into the radiological studies, and they were able to determine by type of doctor, because they knew everybody's passwords. They were able to determine what specialty looked at radiology, at the radiology films themselves most often, when they looked at them. They even ended up saying there's a big drop-off at the end of the week regarding the number of times the scans are viewed, so that they were able to show that everybody's focused early in the week, but come Friday, nobody cares.
In your defense of medical liability claims, what have been the most common errors or liabilities in physician use of electronic medical records? How do you advise your physician clients on avoiding these errors, liabilities in the future?
Well, this is going to be a scary thought because most of the errors that I've had to deal with have actually been errors not from my client, but from some other healthcare provider that adversely affected him. For example, we talk about EMRs being a relatively recent thing, but in certain areas it's been around for a long time. For example, at pharmacies, they would have the individual pharmacists would have each patient's individual drug log, for lack of a better way to put it. And I have had 2 cases where my client got sued, or 2 different clients got sued for having prescribed certain medication, and they weren't the ones that prescribed the medication. The pharmacist inputting it had just input the wrong doctor, because my client was the regular doctor and this was somebody else who the patient had seen out of town or in another clinic or something like that. And I ended up having to go pull the original hard copy of the script from the pharmacy to show that my guy hadn't written the script. Another case I had that I recall was a drop-down box issue where the whole issue in the case was a uterine rupture case after multiple C-sections, and the whole issue was the patient in preterm labor. Well, the nurse who was seeing the patient when she first got admitted, the drop-down box for "Why are you here?" included onset of labor, and that's what she clicked because it was closest. And the patient was like 32 weeks and just had some uterine irritability, but the closest thing to what it was onset of labor. So that's what she clicked. And now the whole trial I'm having to face, well, look, the nurse knew she was in labor. How come you couldn't tell she was in labor? From an individual physician standpoint, I think what I see is again just not paying attention. I actually had a case one time where this wasn't an issue, but the medical records, it involved a patient who had been paraplegic and wheelchair bound for 30 years from an accident he suffered when he was a teenager. Well, my client who is examining him is just clicking boxes, and he clicks gate and station normal. So, the things I see really are almost all related either to somebody else who's not paying attention or to the physician himself who is not paying attention.
HIPAA data breaches are emerging as one of the largest systemic risks a hospital or group faces in the modern healthcare delivery system. What risk management advice would you give physician clients for maintaining HIPAA confidentiality with their EMR system?
There's actually some good news on that, because I think the law recognizes that a lot of times in these breaches, what happens is you have someone within the facility or someone within the physician's office who is using the medical records for their own purpose, for their own reason, just being nosy, whatever, and they tend to be a little bit protective of physicians or hospitals who do a good job trying to police that and who take action after the fact to show that it's not something that will be tolerated. So keeping that in mind, I think the first thing you have to do is you have to get every employee, even the old ones who've been there forever, you've got to get everyone to sign a very strict confidentiality statement. And it's something we actually do in our office. You make them sign something, you put it in the employee manual, and then you make them sign something, say, I understand that the information within this office is confidential, is protected by federal law, is protected by state law. I understand I can only use it for the purposes within this office. I understand I cannot access it except for the purposes within this office. Something that is very, very firm and finite and leaves no question about their responsibilities. Next, I think you need to make them understand what you just asked me about, which I doubt a lot of doctors understand, and that is the metadata situation and the audit trail. They need to understand that they cannot do anything on that system without that system remembering it forever, and that you as a physician will be able to tell who got into the system, when they got into the system, where they got into the system from, what they looked at. You can tell exactly what was accessed. So they need to understand that, because I suspect a large part of this is people thinking, well, I can go to the file. I mean, they could go to the hard copy file and look, and nobody'd ever know. You can't do that with the EMR. Next, I think you have to have a very strict password situation. I don't know what doctors' offices require. Interestingly, a lot of our carriers and our own malpractice carrier require us to have various password requirements, including on our mobile devices, because our mobile devices are a lot of times hooked to our internal server here in the office. So you have to have passwords on your phone. You have to have passwords on your computer. Some of our carriers require the passwords to be changed every so often. So you have to have a very strict password situation. I think you need to be sure that each of your employees understands that inappropriately accessing someone's electronic medical record is a firing offense, and it is a firing offense first offense, without any excuse, without any rationalization. And the reason for that is if the facility or the doctor's office does not fire that person on first offense, they can be deemed to have ratified that person's actions, and now they have lost the protection that the courts will generally try to give to a group that's trying to do the right thing.
Excellent. Well, Whit, thank you for joining us today on Healthcare Matters, and I hope to talk to you again soon.
Sounds good. I hope this helped.
Thank you.